Thank you, and good morning, everyone. It's a joy to be here to see old friends and to make new ones. And I've noticed so far in the conference that obviously we've spoken about legacy, and we've spoken about legacy in a political context within Rwanda, and we've also spoken about legacy within the framework of the value of ICTR jurisprudence in the criminal context largely, whether that would be defining crimes applied by other international tribunals or crimes prosecuted nationally, again, in the criminal context. So I'd like to open the aperture a bit and talk a little bit about the expressive legacy of ICTR jurisprudence within the context of domestic civil litigation in tort for human rights abuses that in turn can lead to reparative judgment awards, whether compensatory or punitive or even just symbolic. And I think to me this is a fascinating area because it suggests that there is value jurisprudentially in international criminal judgments that exceeds the realm of the criminal law and can actually inform tort-based civil rights litigation. And the case study that I take is a statute in the United States called the Alien Tort Statute, or the Alien Tort Claims Act. To give you a bit of background on this. Adopted in 1789 by the first Congress, the Alien Tort Statute is very brief, and it says this: it gives U.S. federal district courts original jurisdiction over a claim brought by anyone against anyone for a violation of the laws of nations. And United States courts have interpreted violations of the laws of nations as meaning customary international law. All right. This statute may have some resonance to you all here in South Africa because one set of litigation brought under it, the Kulumani litigation, has worked its way up and down and across and under and over the American courts over the past several years. The bottom line is this: U.S. courts have been opened for lawsuits by people against either other people or corporate entities for violations of the laws of nations, and that can lead to a civil judgment. United States courts police this statute very diligently. And in 2004, in a case called Sosa, the United States court said the definition of the laws of nations is not frozen in time, as it was in 1789, but evolves. And in order for a claim to be made today, it has to represent a definite and specific norm of customary international law. Just this year, the United States Supreme Court closed the door to foreign claims brought against foreign defendants by foreign plaintiffs that do not directly touch the United States. That particular series of cases arguably has really closed the door to future claims under this statute that don't directly implicate the United States. Still, about 20 years of vivid jurisprudence to me has created a laboratory in which we can really look at what are the sources of international law that United States courts look to civilly to determine whether or not there are violations of the laws of nations. And I've started a research project with researchers at my university, and we're going to look at this. We're going to trace out sort of the etymology of this particular litigation. Hence the ICTR. So this is the research question for now. What role has ICTR judgments played in the lives of American judges when they're called upon to determine the content of the laws of nations? So we've run a research set through these cases, and I want to share with you some of the findings today. In total, we have identified 98 cases in which United States courts in ATS litigation have referred to ICTR, ICTY, or Nuremberg as evidence of the customary laws of nations in this context. The Rome Statute also figures. Of those 98 cases, 25 of them refer to the ICTR. So, one initial interesting question is, what use do U.S. judges make of ICTR judgments in this capacity? And here is the bottom line. U.S. judges view ICTR judgments as legitimate as sources of evidence because the ICTR statute is created by the Security Council, because of the nature of the prosecutorial mandate, and also because of the expertise of the ICTR. And although United States courts don't look at ICTR judgments as creating new rules of customary international law, they turn to them as evidence of pre-existing rules of customary international law. And by and large, in my opinion, as a public international lawyer, most U.S. courts get the sources right on this particular front, and they're using the judgments appropriately. The next stage of the conversation involves, for what points of customary international law are ICTR judgments being cited, being referred to? And to me, this is very interesting, because I think if ICTR folks think of the legacy jurisprudentially of the ICTR in a criminal context, it's not altogether clear that the cases that may most pop into their minds as being probative or relevant are necessarily turned to by American courts in the civil context. So let me run through a little list of the main points of law that United States courts refer the ICTR to. First, the existence of liability for aiding and abetting serious international crimes. ICTR judgments are frequently cited on this point. This is a major issue in alien tort statute litigation because when corporations are targeted as defendants, corporations don't have arms, legs, fingers, so the only way to get them involved is on theories of aiding and abetting, these broad accessorial liability theories. Related thereto, another frequent citation point is what's the appropriate mens rea for finding liability for aiding and abetting. And here we actually have a divide in the international jurisprudence. The Rome Statute, as you know, takes a view that you have to prove purposeful conduct. There has to be a mens rea element to it. So goes the thinking. ICTR and ICTY judgments are cited too as saying that all you need for the mens rea is a knowledge standard. To me, this isn't an entirely accurate description of ICTR jurisprudence or ICTY jurisprudence. It's a bit more detailed, especially now with the ICTY and the Paris-Sech judgment when it comes to the level of sort of specificity and direction that you have to be found culpable. But it is interesting to me that ICTR judgments are routinely invoked as supporting liability for a mens rea based entirely on knowledge. Second major point that ICTR judgments are cited for, that crimes such as genocide and and crimes against humanity constitute customary international law. Thirdly, corporate liability. Here, defendants invoke the existence of the ICTR and its focus only on individual guilt for individuals as implying that there's no corporate liability for international crimes under international law. Other judges have seen the ICTR statute in this capacity and say that the fact that the ICTR or the other ad hoc tribunal doesn't reach corporations is irrelevant for the purpose of whether corporations have liability under customary international law. The definition of genocide is something that has surfaced in American case law to which ICTR judgments have served as an interpretive guideline. The meaning of widespread and systematic for the purposes of attacks under crime against humanity, for the chapeau, also there's a turn to ICTR jurisprudence here. Another turn involves whether non-state actors can commit crimes against humanity. And in this framework, apparently, American judges have divined from ICTR jurisprudence that in order for a non-state actor to have liability for crimes against humanity, that non-state actor has to have de facto control over territory. Another important one involves persecution as a crime against humanity. And here you have a definitions of persecution taken by the ICTR that informs United States jurisprudence in this. And in a fascinating case that just came down this summer, a district court in Massachusetts held that non-violent attacks against lesbian, gay, and transgender individuals can constitute persecution as a crime against humanity, which is a very, very activist interpretation of international law, and cited ICTR jurisprudence on what persecution is in this particular sense. So those are some of the main areas in which, as points of law, the ICTR jurisprudence has surfaced. No one ICTR judgment gets cited predominantly more than the other. It's a real shotgun approach. And you see references mostly to Akeyesu, Nahimana, and there's several other cases, and we can talk about that in greater detail. But there's not like one or another that's sort of primus inter pares in this particular regard. Let me make 4 concluding observations on this. First, my takeaway from this is that ICTR jurisprudence has had a tangible, albeit modest, expressive effect on the content of civil litigation involving international law torts and delicts more generally. And to me, this is an interesting, untold legacy, I think, of the work of the ICTR. And as you know, anyone who's read anything I've ever written knows I'm not exactly enthusiastic about the retributive, deterrent, or reconciliatory value of trials. I am more optimistic of expressive legacies and expressive value, and to me this is an interesting indicia of that. Second point, when American judges look at these international ad hoc tribunals and international law, they do look at the ICTR, they also look at the ICTY, and they also really like Nuremberg, all right? For some reason, Nuremberg weighs mightily in the American consciousness, all right, as being really relative and relevant, all right? We can get to that in Q&A as to why that is. We can have some collective national therapy session on that, okay? That's a different point. The ICTY is cited to way more exhaustively than the ICTR. So what often happens is, although you've got 25 hits to ICTR and 25 hits to ICTY, generally the bulk of the conversation involves ICTY cases. And then the ICTR cases are sort of added on. Not as callously as being in a string cite, but it's kind of, you know, leftovers, I guess, in a sense. And I don't say that dismissively, but to me, I say it in the context of underscoring how the American courts kind of look at the ICTY and the ICTR as brothers or sisters, right? Different sides of the same coin. When in reality, of course, that's not true. And I actually think some of the real quality of ICTR judgments gets lost in this particular shuffle. And then, of course, there's Nuremberg, which we'll talk about later, which overshadows everything in this particular sense. The third main point that I will take away from it is I've talked about a bunch of areas that ICTR judgments have informed. But, you know, that's not shotgun. Some get talked about much more than others. And the 2 major legacies in American civil jurisprudence under the Alien Tort Statute involve A, the definition of crimes against humanity, in particular widespread and systematic, and B, aiding and abetting. And as I said earlier, the appropriate mens rea. So the legacies here are not the definitions of genocide so much. They appear, but incidentally. They're not so much the cutting-edge jurisprudence on sexual violence. They're not so much jurisprudence or conversations about corporate liability. It's really widespread, systematic, and aiding and abetting. And what's a final interesting point of takeaway here? And I think what we need to do better as international criminal lawyers is recognize that we don't just live in one isolated silo within the international legal framework. What we think about and what we do migrates, it cross-pollinates, it informs elsewhere. And I think if we want to have a real honest conversation about what justice after conflict means, we have to get outside of the box of the courthouse, the jailhouse, the trial, and, the sentence as this iconic form of what justice means. We have to step outside Nuremberg's halo, and now we got to step outside the halo of the ad hocs and of the ICC. And I think having more research that looks at other forms of justice and the connectivity of other forms of justice with what we're talking about here and now, namely criminal responsibility, is not only a good way forward to think about what justice actually means, but also to recognize that international criminal lawyers may actually touch the world in ways that we don't anticipate and that go beyond our actual narrow mandates. And to me, this is a legacy. No one's really talking about it, so I thought I would talk about it because I like talking about things that no one's really talking about, because I like talking to myself. I don't know why, but so be it, and thank you for your time.